So good morning, everybody. Hope you've been enjoying our little conversation here as we get started. Just for introductory purposes, I'm David McCaleb, Vice President of Marketing here at Bankers Insurance, and with us today is Jamie Hasty from SESCO, Vice President at SESCO Management Consultants. And we have a really awesome topic for you today, navigating the complexities of wage and hour law. But before I get started, just a little bit of housekeeping. At the end, anyone who has registered, or if you're attending, obviously, but anyone who is registered, we will send out the video of this particular call. And so if you miss something, no worries, you will be able to get a video. It'll be a link to the video. We're also going to send, Jamie's kind enough to send the PowerPoint presentation as well. So I'll include that when I send out that link. Questions. When you have a question, just pop them into the chat feature, and we'll either, if we can get to them while on topic, we'll try to get to it then. If not, we'll have a Q&A session at the end. And with that, I'm going to turn it over to Jamie Hasty.
Thanks, David. Good morning, everybody. Thank you so much for joining us. As David mentioned, this is a really good topic. What we find, especially in the consulting and employment regulation world, is that wage and hour is your #1 compliance liability. And because it is so complex and can be at times very industry specific with the complexities and the partial exemptions and field operation handbooks, all of these things play into, you don't know what you don't know. And that's okay, but what we want to do is be in a good position to educate you on certain things so that, you know, we can negate as much liability as possible. Just to kind of piggyback off of what David mentioned with regard to the chat feature. So I will do my absolute best to answer. And David, feel free to stop me and interrupt me too in the moment on that particular slide, because a lot of, again, what we're talking about is incredibly complex and situation specific. We will do our absolute best to get to those questions, but if not, I think that there's a way we can download those and then answer them and send them out to the group later. So hang with us. We will do what we can. I'm gonna go ahead and share my screen. And we should be good to go there. Yes. Okay. So just actually, before I jump in, a little back history on SESCO. So one, we've had a long-standing relationship with Bankers Insurance and their clients. So we are incredibly appreciative for that. But actually, SESCO was founded in 1945 by a former wage and hour investigator back a few years shortly after the Fair Labor Standards Act went into play. So when we talk about expertise in wage and hour regulation, it's the foundation of what SESCO was built on, okay? So it's something that I deal with clients in all industries throughout the country on a day-to-day basis. We regularly represent clients in front of the DOL regarding these type of audits and investigations. So if you have questions and have access to us through Bankers, or you're a Bankers employee, an account manager, a associate, and you're getting questions from your clients in that capacity, please feel free to use that relationship to walk through some of these things. So let's kind of lay the groundwork for wage and hour accounting and regulations, and that stems from the Fair Labor Standards Act. I call it FLSA because saying the whole word is it's a little long-winded. So FLSA was basically there to kind of put minimum standards in place, right? Minimum wage, overtime, child labor, making sure that, you know, employers were not taking advantage of workers and not paying them what they were worth, in essence. Not, you know, giving them a 75-hour work week at, you know, back in the day, I think the original minimum wage was like 35 cents, something crazy, right? So it really is intended there to make sure that there are minimum standards, that people are paid overtime appropriately, and that's on a federal basis. Now, let's take it down to the state level. Every state has its own state-regulated and state-supported Department of Labor, okay? Within those departments of labor on the state level, they will also have their own wage payment regulations. If you're here in Virginia, you may remember that last year there were some major changes to the Virginia Wage Overtime Act, at which was actually rescinded effective January 1, with the exception of one certain provision on a civil litigation piece. But if you are in North Carolina, Tennessee, West Virginia, Maryland, DC, each one of those respective states or districts has their own minimum wage, how often people are paid, rules around deductions. So it's not uncommon for a particular state not to follow the FLSA. So for purposes of our conversation today, we are looking solely at federal Fair Labor Standards. Okay. If we want to dig in individually on a sidebar regarding state specific, I'm more than happy to schedule that conversation with you individually. So just want to throw that out there. When we talk about liability, wage and hour is your #1 financial liability of any of the federal employment regulations. Why? Because if you get an audit, they will pull the previous 2 years of payroll, including time cards, and they will run calculations. They're looking for misclassifications on salary and exempt status. They're looking for short lunch periods that you've docked them for. They are looking for people that are 1099s that really shouldn't be 1099s that you owe minimum wage and overtime to. They're looking for, are you paying somebody that's hourly and eligible for overtime, a bonus, or a commission? Did you pay the extra overtime on that bonus and commission? Okay, so the numbers add up. If your penalties for the last 2 years are $50,000, it automatically is doubled under what we call liquidated damages. Okay, so that automatically becomes $100,000 that you owe. By the way, there is no payment plan on that. You're cutting checks within the next 30 to 60 days individually to every single employee that ever could have worked for you or did work for you within the last 2 years. Okay. So when we look in the last 5 years, more than 1.3 million individuals within the United States received some sort of back wage payment from the Federal Department of Labor. Okay. Keep in mind, on a state level, there are some states that allow for employees to circumvent the Department of Labor through their complaints and go straight to civil litigation and civil lawsuit for back wages and failure to pay appropriately. And Virginia is one of them. Okay, so in the event that you have ever been audited by the Department of Labor prior, if they come back in to audit you, they will pull 3 years, okay, because they're looking for willful violations. In the event that there unfortunately is a lot going on when they initially start auditing you, they can move it straight to an FLSA lawsuit, which then pulls a 4-year liability, plus attorney's fees, plus compensatory damages, plus. It adds up. So, common misconception out there is that OSHA, the safety side of things, can be your most expensive liability. And the reality is it is not. It's wage and hour. I have seen, unfortunately, way too many businesses, both Fortune 100s all the way down to small family-owned businesses. We had a client up in New York a few years back that had 2 or 3 locations, and they thought, they were doing it correctly. They were, under the impression the employees didn't want to be on hourly. They wanted to be on salary. That's what they liked. Didn't realize that they couldn't do it that way, even though the employees said they wanted salary. So all good intentions, right? We're trying to help our employees. They like salary. They don't want the overtime. Well, that $2.3 million back wage calculation shut down their business. Okay. So it is very, very costly, and it can cost the business in its entirety. And I say that not to scare you. I say that as the reality of 15 years of consulting experience and dealing with wage and hour. For the most part, FLSA covers pretty much every organization, but they do specify enterprise coverage. So meaning we have at least $500,000 or more in gross annual sales volume. And that we are engaged in commerce, producing goods for commerce, or handling, selling, or otherwise working on goods that have gone through interstate or intrastate commerce, meaning they've come in from across state lines somewhere throughout their production process, right? You also have individual coverage. An employee is covered if he or she is engaged in interstate or foreign commerce and producing goods for transportation. It is few and far between when organizations are not covered underneath FLSA. Okay. Occasionally you'll run across a religious organization, a small church of sorts that's not going to rise to the threshold of the 500,000. But for the most part, 99.6% of everybody that runs a business is going to be covered. So with FLSA, there are some key components. Again, remember, we're talking federal here. All employees must receive at least federal minimum wage. Again, if you operate in a state that has a higher minimum wage, that higher minimum wage must be paid. You can't say, oh, well, federal's only $7.25, so I'm going to pay the $7.25 instead of the $11 or the $12 or $13 if you're in New York. Okay. They also must maintain a true and accurate time card. And last but not least, they are eligible to receive overtime at 1.5 times their regular rate of pay for any hours that exceed 40 in a work week. Each work week stands alone. Okay. So many clients will pay on a biweekly basis and say, oh, David, you know, you only worked 35 hours week 1 and 45 hours week 2. It's a total of, 80, right? And my math may be off, so bear with me. But nonetheless, you can't average the work weeks together, okay? Each work week stands alone. So everybody's entitled to minimum wage. Everybody has to keep a time card. Everybody must receive overtime at their regular rate. And I will discuss in length what regular rate means, because it is not just the hourly rate of pay, okay? Unless you are considered exempt from overtime, okay? So for the most part, these are the core bases of FLSA. Then we run into salaried exemptions, okay? So first and foremost, just because you have a manager title does not mean that you are exempt from overtime. Okay. Just because you are paid on a salary basis does also not mean that you are exempt from overtime. There are duties tests for each of the exemptions, and we're going to walk through those full exemptions from overtime. Let me clarify that. Plus salary amounts. Now, prior to January 2020, the guaranteed salary amount to even potentially be considered exempt from overtime was only $455 guaranteed per week. $23,660 a year. It's not very high, right? So for years, I mean, going back to 2014, there has been this ongoing push to increase the salary threshold for exempt status. And under previous administrations, it was, suggested at 900 per week. Then they got pushed back, so DOL kind of cut that. Long story short, fast forward to January 2020, guaranteed salary of $684 per week. First test. If you're not making $684 per week in guaranteed salary, you're not exempt. You can't even be considered for exemption, okay, under full exemption. So guaranteed means guaranteed. If I work at any point in time within that week, I'm guaranteed that full salary, okay? There are rules surrounding docking from salary, and we'll cover those here shortly. So that was a huge jump, okay? The last time that DOL ever revised the tests surrounding exemption status was in 2004. Okay, so that's a pretty large gap. And the intent was to bring people kind of back into more of the mainstream realistic salary thresholds. So there is a provision within the revision to FLSA with the exemptions that you can use up to 10% of the guaranteed salary level with an incentive or a commission to make them whole for that guaranteed salary. If you plan to do that, you need to collaborate with SESCO, another HR consulting firm, an employment attorney, somebody that is a wage and hour expert, to make sure it is structured properly. Okay, it's a catch-up one-time payment of 10%. Okay, if somebody did not make it, but generally speaking, $684 guaranteed per week. But if you plan to use a bonus or a year-end commission to bring them up to that threshold, again, you need to seek expert counsel on that to make sure it is done properly. Here is a list of your full exemptions from overtime. We're going to dig into each one, okay? A couple of comments on your exemptions. It is an all or nothing approach. You either meet all of the tests or you meet none of the tests. You don't get to cherry pick within it, okay? With full exemptions from overtime, they do not need to maintain a time card, okay? So full exempt means full exempt. I'm on the salary, I'm meeting the duties test, don't have to keep a time card, okay? So you've got executive admin professional, which could be a learned professional or a creative professional, okay? Computer exemption, outside sales, and highly compensated. Let's dig into executive. This is the easiest one for us to look at and determine if it is applied correctly. So with the executive exemption, I am a manager of 2 or more full-time employees within a department or division of an organization. Those 2 employees within that department must report directly to me. If I have 1 full-time but 2 part-time, the 2 part-time equal 1 full-time, okay? I have to have the ability to hire and fire, or make significant recommendations to hiring and firing. I need to be spending at least 51% of my time each week actively managing those direct reports, coaching, counseling, disciplining, directing their work, performance reviews, all of those things, 51% of the time. Okay. Typically speaking, these are general managers, department heads, vice presidents, so on and so forth. But it's the easiest one for us to look at and determine, do you have 2 or more full-time? Can you hire and fire? And walk me through your general work week. Now, where some smaller organizations can get into a little bit of trouble is when you have an active working manager. I'm technically a manager of this department or division, but I'm actually spending the bulk of my time doing the exact same type of work that my direct reports are doing. But occasionally I'll coach or I'll counsel or I'll screen and hire. I'm more of a lead for that department. That's not going to work. Okay. If you have individuals that are reporting to 1 or more managers, that's also not necessarily going to work. Okay. So when we talk about executive exemption, I'm also going to want to see that the job description is incredibly reflective of these high-level managerial duties. Okay. And we'll talk about why that's important when we get to the section on the audit. The administrative exemption is your most commonly misapplied exemption for most organizations. Everybody wants to try to use the admin exemption for office staff, for accounting staff, for receptionists. And it's commonly misapplied because of the way that the regulation is written. It's very ambiguous. So with admin exemption, again, guaranteed salary $684 per week. I have to be doing office non-manual labor. Okay, that's easy, right? We can determine that. Where it gets really kind of squirrely is I need to be spending 51% of my time doing work that requires independent discretion and judgment for matters of significance that are directly related to the overall business operations. Well, tell me what that means, right? So, easiest way to look at it is, do I have somebody that has the ability to make their own independent decisions and judgment calls for high-level things? Budgetary decisions, capital expenditures, strategic vision type high-level decisions. Do they have the ability to modify policy and procedure without running it by anybody else? Okay. Independent, high-level, business impacting decisions. Anything that is considered very routine and regular or recurring, for example, accounting. And when I say accounting, I mean payables, receivables, data entry, just basic general ledger type stuff that, yes, could potentially impact business operations, but is very routine, repetitive. Like it's cut and dry. It's following a step-by-step process. There's not a whole lot of discretion and judgment and veering from that pre-established process, right? Anything that is routine and repetitive in nature is going to negate this exemption. Okay. So generally speaking, when you have AR, AP, payroll type people, HR generalists that are not making those high level decisions, they're not going to meet the level of administrative exemption. Okay. However, you may have a one-person controller that's doing high level budgets, high level capital expenditures. Yes, they may be doing AR and AP or occasionally, but not a ton, right? So you may have controllers or a one-person CFO that would meet the definition. And if they have a CPA designation, then we're talking about a different type of exemption, okay? Your full-time HR manager, assuming they are not serving in a generalist type role and doing more of the administrative processes, could also potentially qualify as well, okay? So, with your professional exemption, so you've got two technical categories of it, learned and creative. So for purposes of this slide, let's talk about learned. These are your doctors, teachers, lawyers. Okay. High level advanced degree, generally master's or above. Okay. Certain positions do allow for bachelor's degrees, and we can dig into that a little bit more specifically. Advanced knowledge in a field of science or learning is the way the regulation is written. They must be paid on a salary or a fee basis, guaranteed salary of $684 or a fee basis that meets within that week the $684. Okay. A fee basis would be, Jamie, I'm going to give you $500 for you to do this task. How you do it, how long it takes you is on you. But for every repetitive task that you do, you're earning this amount. And at the end of the week, I've earned past the 684. We're good. Okay. So generally it's a professional degree. If you're talking about like social workers, for example, they need to have a master's degree in social work in order to be classified under the professional exemption. Okay. If you're talking about registered nurses, an RN with a 4-year degree is going to qualify for the professional exemption, but an RN with a 2-year degree would not, per the wage and hour division. Okay. Remember, advanced study. So generally master's and above, but there are a few scenarios where 4-year degrees can qualify depending on that. So therapists, PT, OT, LCSWs, doctors, lawyers, teachers, all of those are generally under the professional exemption. When you talk about the creative side, that is generally, trainers, lecturers, philosophers, those sorts of things, but you generally don't see that creative professional exemption applied too often, although it does happen. But for example, I had a question a couple of weeks ago about a corporate trainer. Okay. And so some of the questions that I ask when we have those in-house like trainer or educator positions is, where is the content coming from? Are they creating their own content? And I don't mean just putting together a PowerPoint. I mean literally writing content and creating these training programs and rolling it out and facilitating and creating digital media around it. All of these things, that high level type work that would require, bachelor's or master's degree in these techniques and their education piece. Okay. So you've got your professional exemption, which is actually also pretty easy to look through and determine as well. You have your computer exemption. Where we see a lot of organizations run into trouble with this particular one is that they put their general help desk, website managers, network administrators on a salaried exempt status. And it's just not going to work. These are high level programmers, analysts. They're writing code. They are developing softwares. They're doing more than just general IT support. Okay. So that's pretty cut and dry there. Outside sales does not have a salary requirement for it. The only requirements for outside sales are that I am spending at least half of my time outside of the office engaged in sales, which requires me to be able to negotiate contracts, obtain contracts, and navigate those contracts. Okay. Anybody that's doing primary inside sales is not going to work. Okay. If I'm sitting behind a desk making phone calls, that's not going to be considered outside sales.
I'm going to interject real quick. I know Jamie's doing a fantastic job here, but if you guys, I just want to remind you, if you have any questions, by all means, go ahead and type them into the chat feature and let us know. Yeah.
Thanks, David. So highly compensated, if they are paid on a guaranteed salary of $147,000 and some change, as well as, meeting the duties test under executive or administrative, they're going to be considered highly compensated. Now, again, if they're making the 684, technically they're already executive or administrative exempt anyways, if they're meeting those tests. So you've got the highly compensated designation, but they could also be qualified elsewhere. Okay. So those are our full exemptions from overtime. Remember, all or nothing, salary plus duties, and they don't have to keep a time card. There are roughly 100 other different types of partial exemptions from overtime through the Code of Federal Regulation. Okay. Most of them are industry specific. But when you have a partial exemption from overtime, it doesn't remove the time card requirement. Okay. Remember, all employees have to make minimum wage, receive overtime at 1.5 times regular rate of pay, and keep a time card unless they are fully exempt. A partial exemption removes the overtime requirement, but does not remove the time card piece. Okay. So if you work in the automotive dealership world, you've got an automotive 13B10 for your sales, parts, service techs, and service advisors. If you are in transportation, you've got your motor carrier 13B1 for drivers, helpers, loaders, and mechanics. Okay. If you work in agriculture, there are exemptions that can be applied to farm workers depending on their duties and how they're structured. There are also additional partial exemptions from overtime for seasonal and recreational workers. So if they're working in King's Dominion or Busch Gardens or Six Flags, none of those kids make overtime. Technically, they don't have to make overtime, but the company could choose to pay it. Okay. So there are a ton of different partial exemptions from overtime that may apply based on your industry. Okay.
We do have one question, Jamie, going back to the professional exemption.
Yep.
The question was, hey, do architects fall in the professional exemption? There's a 4-year degree and licensure is required.
It probably could. What we would do is look at wage and hour regulation as to have they issued opinion letters on architects, and then we also have to look at the state, the regulations surrounding the licensure and how that ties back. So generally what happens when you have a 4-year type degree with a licensure, so architecture or in the example of the social worker, same thing. Wage and hour will say if that licensure is based on certain accredited education pieces, then it may qualify under the professional exemption. So certainly happy to discuss that more one-on-one with that particular individual, but I think it's safe to say that yes, it is likely that it would qualify, but we would just need to look at the specifics of the licensure to make sure that we're good to go there.
Gotcha. And that, just as a little clarification, that person replied, North Carolina, landscape architects as well. Another question.
Maybe.
Go ahead. Did you want to comment on that? I'm sorry.
Maybe. Again, I think that's one of those that we would have to dig into more specifically for their organization.
Okay. So another one came in. Our case managers are currently classified as exempt. A specific 4-year degree is not required, but each must be licensed and credentialed. Should these positions not be salaried?
It depends. I don't like it. Let's put it that way.
And just to let folks know, like we can, if there are additional questions afterwards, we can, if you speak with your sales executive, whoever invited you, we can get you in touch with SESCO to be able to handle some of these questions kind of offline as well. For these questions that maybe there's some gray area that we need to talk through. We can most certainly do that.
All
so
great
again,
questions.
Yeah, they are great. Another one. This one's going back to the landscape architects. They have had to graduate from an accredited program and have 4 years experience.
Yeah, no, that's not going to work.
Okay. May need to take that one offline too.
Yeah, we got to take that one.
Good questions.
Yep.
Good questions.
Wonderful questions. And that's why I said this is one of those sessions where I know we're going to generate 70 questions, but because they can get so specific on what the particulars are of that particular situation, position, person, organization, it may be a situation where it is more appropriate to discuss more in detail one-on-one.
And I will just interject. I apologize one more time, Jamie. As if you are a client of Bankers Insurance, then we provide this access to SESCO, limited email and phone support, and it's free. If there's something more in depth that needs to be a separate project, you can negotiate special rates with SESCO. But I did want to let you know that is a benefit of being of a client of Bankers Insurance. If you were invited here, you're not a client of Bankers Insurance, talk to the sales executive, whoever it was that invited you, and let's get you on board.
Yep, no, I love that. Okay, cool. And so another partial exemption from overtime is our retail 7I. That is available to organizations that are engaged in retail sales, where the position may be engaged in retail sales, where at least 51% of their total income is coming from some sort of form of commission. And so when you take their total monies earned divided by their clock hours, they have to average an hourly rate of pay, including the commissions, of at least 1.5 times minimum wage. So in this example, remember, we're talking federal here. 1.5 times 725 is an average of 1088 per hour. Okay. I'm just going to use Virginia off the top of my head because I've been using retail 7I a lot this week in audits. So Virginia minimum wage right now is $11. So 1.5 times 11 is $16.50 per hour. Okay. So again, going back to your state, if you have a higher state minimum wage, this average is going to be higher here. And then they still have to maintain time cards. So I broke it down in an example for you. Let's just say you pay me on a $600 a week salary. Okay. So at the end of the month, I've earned $2,400. Okay. I have to make another $2,400 in commission that month to even satisfy the 50-50 test. Okay. Then when I take the total monies earned divided by the total clock hours for the month, it has to yield 1.5 times minimum wage. Okay. It's an option. 7I can get pretty complex. Again, you don't implement sort of partial exemptions from overtime without working side by side with a wage and hour expert. Because if we misapply it, it can come back to bite us very quickly. Okay. So just some basic recommendations. One, you should be doing a wage and hour audit at least annually, if not every other year. Especially if you are within an industry that has complex pay plans. You're doing a lot of bonuses or commissions, that sort of thing. You need to be looking at who's on salary, what's the threshold, do they meet the duties test? If not, we need to make some changes. Who's keeping a time card? Who's not keeping a time card? If they're potentially misclassified, need to make some changes. Who's working overtime? Can we manage that down without changing the salary structure? So again, these are all things that your HR consultant works with you on to make sure you're in the most compliant position possible in negating that back wage liability. Okay. There is an alternative method of payment called the fluctuating work week method of payment. And let me make this very strong caveat. With fluctuating work week, it is a guaranteed salary for all hours worked. It's straight time. So if I'm making a $679 per week, that's covering my 45 hours for that week. But I'm not exempt, so I still am entitled to overtime, right? So the salary covers all hours, but you still owe me the half time for the remaining 5 hours that exceeded my 40. Okay. FWW requires a letter of understanding signed by both the employer and the employee. It is not the best pay plan for every situation. It is simply an option. This is not Jamie at SESCO telling you to put everybody on FWW. Okay, been there, done that. This is me telling you it is simply an option. If you have a non-exempt manager or somebody you want to put on salary and you know you still have to pay the overtime, it's a way to pay overtime correctly while maintaining a salary option for them. The downside to FWW is that they basically, the more hours they work, the less that hourly rate becomes. Okay, so again, it's not always the best pay plan option for some businesses and for some individuals. If you want to talk more about FWW, I'm happy to do that. Do not implement it without getting it vetted by an employment attorney or an HR consultant. And David, I see your eyes moving back and forth. Do we have questions?
No, ma'am.
Okay, cool. So there are a few options. When you are doing your audit and you realize that we've got people misclassified. Obviously, I'm not going to suggest that you do nothing and roll the dice, but I can simply only give you the options, okay? There are some organizations that choose to roll the dice. Obviously, you can make adjustments to salary. You can modify job functions and duties to bulk them up to where they're meeting the duties test. You can convert to an hourly rate with overtime. You can consider FWW. We can look at possible partial exemptions for application there. Okay, so there are options to get you back into compliance. I mentioned the myth when we got started that paying somebody on a salary basis does not automatically guarantee their exemption status. It's duties plus salary, all or nothing approach. Before I roll into some common traps, do we have any comments, questions? And I feel like I'm getting close. How long were we scheduled until 12:30?
Yeah, we scheduled it till 12.
Okay, we're probably going to run over. So whoever can hang with me because it's good stuff. I don't want to rush, but I'll be mindful of time. But we're going to roll over 12.
Yeah, no comments or questions at this time, but by all means, just if you guys have them, go ahead and put them in there and we'll either get to them or get to them at the end, either way. Yep,
awesome. So trap number one, obviously, misclassification of non-exempt employees as exempt. These are some positions that obviously Wage and Hour commonly looks for. Trap number two, employees cannot waive their rights. You know, I mentioned that example client in New York of the employees wanted to be on salary. They didn't want the overtime. Doesn't matter. The law is the law. Just because employees say, oh, don't pay me this, or sure, you can deduct that without some sort of signed agreement, employees cannot waive their rights. So regulation is going to be set, and that is what the auditor will go by. Trap number three is not understanding what is considered hours of work. There are very specific pieces around break time, travel time, meetings, and training time. Basically, anything that would be for the benefit of the employer is going to be considered compensable time. Got a great question yesterday from one of my clients about new hire paperwork. And they were like, listen, I would really love for these people to kind of fill out all of their new hire paperwork before their first day. Do I have to pay them? And the answer is yes, you absolutely do. Why? Because it's for the benefit of the employer. You're causing them to engage in quote unquote work at that point. Okay. So break time, depending on what state you operate in, you may or may not have required break time. But for the most part, on a federal basis, there is no required break time unless you're talking about child labor. Okay. If a break is under 30 minutes, that time is considered compensable under FLSA regulation. In order to not compensate for a break or a meal period, it has to be 30 minutes or longer in duration where the employee is completely relieved from work. So what I look for when I'm auditing time records is short breaks, 25 minutes and under, where perhaps somebody clocked out, ran down the street to Wawa, grabbed something, ate it real quick, jumped back in for whatever reason. That time, that 25 minutes has to be added back into the total time worked for that day. Okay. If you have an automatic timekeeping system, it may not catch it if it wasn't set up to add it back. Okay. So payroll folks, managers should be watching for short break times. Travel time, depending on when they start, when they stop, where they start from, where are they going? Is it overnight travel? Is it same day travel? Is it travel on days that they would normally not work? There are specific rules around how you calculate travel time for certain folks. So that could be an area of liability too. Same thing with meetings. Any sort of required meeting or training that is for the benefit of the employee or required by the company is time owed to them, even if it's on the weekends or in the afternoon. So Portal to Portal Act. Ooh, say that 5 times fast. Talks about travel time. Okay, so home to work, ordinary normal travel is not paid time. Even if you're commuting an hour from your house to your office or to your work location, it's not travel time. But let's just say I'm traveling between offices. That is compensable time. So I leave office A and I go 45 minutes up the road to office B as an hourly employee. That 45 minutes counts as time owed to me. Okay, because it's between locations. Travel away from home, home to work on special one-day assignments. You know, let's say I'm here in Richmond and I'm an hourly employee and I leave my office at 8 a.m. to drive down to a conference in Raleigh that ends at 5 p.m. and I drive back from Raleigh to Richmond, which is 2.5 hours. From the time I left at 8 to the time I get back to the office to drop off my coworker, that's all paid time. Same day travel. Okay. The things that we look for is the attendance outside the regular working hours. It's voluntary. Are they being productive while they're working? I actually got a question last month about a work trip that was more of like one of those gifted trips, President's Club, or you know, a vendor that the company was working for gifted our top 5 salespeople this like all expense paid trip to Hawaii, but they took work calls on the trip. Do I owe them that time? You absolutely do. They worked. It was for the benefit of the employer. You can't take the vacation day if they were answering emails and calls while they were on that trip. Okay. So there are rules surrounding that. Trap number 3, again, kind of dealing with hours of work. We mentioned working lunches. Also, pre and post work. So a lot of times, especially with clock hour employees, they'll clock in early or clock out late. All of that stuff adds up into overtime. Or if you require your staff, perhaps we work in manufacturing or diesel work or other things where they may be required to wear a particular uniform, and we require them to change into that uniform on property. All of that changing time, it's called donning and doffing pay. All of that time is compensable time as well. With technology, we also have to be very careful about emails, calls, after hours, on weekends. If you have somebody that is non-exempt, technically that is time owed back to them. Okay. And then in particular with unauthorized overtime. If somebody is working overtime and it has not been approved by that manager, yes, you still legally have to pay it. Yes, it also becomes more of a managerial issue and a disciplinary issue if they are working unauthorized overtime. But you can't dock them that time because they didn't get permission. Okay. So those are some traps that we see there. I've mentioned regular rate a few times. Okay. So common misconception, especially when we're talking about overtime, is that I only use the hourly rate of pay to calculate overtime. Well, what happens when I earn a monthly bonus? Is my $15 an hour really 15? No, it's not, because the bonus is added into my total wages earned for that time period, right? it makes my $15 an hour really be $18 an hour for that week. What if I'm an employee that is earning multiple rates of pay for doing different types of job during the week for your particular employer? The average of those rates is the regular rate of pay. So all work time has to be included for regular rate purposes. So do non-discretionary bonuses. Any bonus that is tied back to some sort of metric. David, if you hit this metric, you're going to get X or Y or Z. You know, if you meet this goal, you're going to get $1,000 or $500 at the month end or quarter or every week, whatever it may be. Those non-discretionary bonuses must be included in the overtime calculation. Okay, because again, it's total monies earned. Can't average work weeks. And let's talk about comp time. Okay, comp time is not paid time off. Okay, people like to use that term interchangeably. Comp time is basically saying, Susan, you've worked 45 hours this week. I'm only going to pay you for 40. And instead of paying you the 5 hours of overtime, I'm going to give you 5 hours of PTO into your bank. It's comp time is purposely not paying the overtime in the week in which it was earned by giving them a value in paid leave later for use. That's not okay under federal wage and hour law for private employers. Public sector employers can actually use comp time. That's the way the regulation is written. Is it fair? Many don't think so, but comp time is illegal, and wage and hour will jump all over you for it. We talked about overtime on bonuses and commissions, whether that be month end or quarterly. Basically what you do is you have to pay the extra halftime on the bonus. So if I'm an hourly employee and I get a month end bonus of, let's just say $1,000, I have to look first and foremost, did I work overtime within that month that the bonus was earned? If I didn't, no big deal. You don't have to do anything. But let's just say I did out of 2 weeks. So I take that $1,000 bonus and I divide it out by each week. So 1,000 divided by 4 is what? $250 per week, right? I have to then pay the extra overtime on that $250 that was applied to that week. So perhaps I only worked 42 hours that week. So I use my little bonus and coefficient table and I scroll down and I find 42 hours even, and I scroll over and it gives me a coefficient. So it's like 0.0, I'm just making up numbers off the top of my head right now. It's like 0.0062, okay? I take the 250 times the 0.0062 and it says, I owe Susie an extra $4.35 in overtime for that week. Okay. And you repeat the process. What you got for me?
If an hourly employee works 33 hours or more in a week with a paid holiday of 8 hours, which is now 41 hours, do you have to pay overtime for the 1 hour or is it all straight time?
Ooh, that's a great question. So paid holidays and vacation and sick leave do not count for purposes of overtime. That's why your payroll records need to clearly show if they're taking vacation or a holiday, it should show regular hours and then holiday hours. So that if an auditor looks at your pay stub, instead of them seeing 41 hours total, it's going to show 33 regular, 8 hours of holiday. And they know, yes, total hours was 41, but 8 was holiday, and it doesn't count towards the overtime.
Fantastic. Got one more. Could you give an example of legit comp time is the question.
I think in my example that I previously gave was, look, if David works 45 hours this week, and I say, David, you're eligible, you're owed the 5 hours of overtime, but instead of me paying you that 5 hours of overtime this week, I'm going to give you 5 hours of PTO instead in exchange. Okay. That is comp time. That is purposely avoiding the overtime payment by giving a value equal to overtime and some sort of other fringe benefit. It's illegal. You can't do it. Okay. Any other questions before we?
She followed up with a question, or is all, talking about the comp time, is all illegal? I think there's still some confusion there. Maybe she's looking for, you know, like how you do comp time legally.
You
can't
do comp time legally. You owe the overtime, period.
Okay. I think that probably answers it.
Yeah.
And another question came up, how does comp time work for exempt? Or does it even apply?
Yeah, that's a good question. For exempt individuals, it's a non-issue because, again, they're not entitled to overtime. So if you have somebody that, you know, number one, if you're exempt, it doesn't matter how many hours in a week you work. You can work 60-hour weeks. Now, if you're talking, let's just say my CEO comes and says, Jamie, you know, you work 60 hours this week, take off 2 days next week. Doesn't matter. Okay. Because again, I'm salaried exempt. I'm not entitled to overtime. Comp time is illegal when we're talking about non-exempt overtime eligible individuals. It's a good question.
We've got a couple more. How are you doing on time? Do you want to follow up at the end, or
you can answer them?
Says we were thinking we could offer comp time if someone worked a holiday instead of taking the day off.
That's
well,
not
that was
comp time. So I think people like to use the term comp time, and I think it muddies the waters. Call it a flex day. It's not comp time. Comp time is not paying your overtime. Comp time is not saying, oh, David, you worked the holiday, so I'm going to give you a floating day to use elsewhere. Don't call it comp time. Call it something else. Call it a flex day. Call it a floating holiday.
okay, and that may go a ways to answer the next one, which was when can you use comp time? Maybe that needs to be clarified. Like what is comp time? When can you use comp time?
Okay, again, I think the people need to stop using comp time.
Okay.
Paid time off is not comp time. And I think what their questions are surrounding is using paid time off or a flex day versus comp time, which is avoiding overtime payment.
I think that clarifies it.
Yeah. So, I say don't use the term comp time because if employees are using comp time, that terminology, a major red flag will go off in the auditor's head. And then you're going to be stuck trying to explain it. And they may or may not accept your explanation if your record keeping is not correct.
That makes sense. So avoid that term.
Yeah, it's just, and I know a lot of people do it. I mean, I hear it literally daily. And I'm like, well, but you're not really talking about comp time. You're talking about paid time, which is different. All very, very good questions.
But that's all we got for now.
Okay, cool. So in the PowerPoint, there will be examples on incorrect way of paying overtime on a bonus versus the correct way. All right. Also, please note that if you have somebody that is hourly, overtime, and bonus or commission eligible, Your payroll company may not be doing it correctly. Do not make an assumption that your payroll company is calculating the halftime or the overtime on the bonus. That's why you need an audit, okay? There are exclusions from regular rate calculations. Like I said, vacation, holiday, illness, all of those things don't play into the overtime calculation. Discretionary bonuses such as holiday bonuses that nobody is guaranteed to get but are given occasionally, those things are fine. Anything that would be part of a irrevocable trust does not have to also be included in the regular rate. Trap number 5 is making deductions from an employee's pay without authorization to do so, or dropping them below minimum wage. So what I often see is that an employee has been let go. They have one of our company uniforms, and either A, I want to hold their paycheck until I get that uniform back, or B, I'm going to deduct X number of dollars from their final pay because they never returned it. And I'm going to push back and I'm going to say, number one, you can't hold their paycheck legally. And number two, do you have a signed written authorization that allows you to deduct the full amount? And did the authorization clearly outline the agreement to that amount as a one-time payment for failure to return? If not, you're not deducting anything. And thirdly, we need to make sure that any deductions, and we're not talking about FICA and state taxes and Social Security tax. We're not talking about taxes. We're talking about deductions for materials, equipment, uniforms, that sort of thing, equipment damage. Perhaps we allowed the employee to charge something to our account for a product or service that they received from the company, and we're having them repay that. Any of those quote unquote repayments or deductions can never drop the employee below minimum wage for all hours worked. Okay. If we do, we've got a problem. There should be a very specific signed authorization form for every deduction, including medical and dental and vision premiums. Okay. The employees have to voluntarily agree. Trap number 6 would be the fact that we have misclassified independent contractors. It is generally very difficult to 1099 somebody. Okay. If the employer has any sort of control over the individual, when they work, how they work, what materials they are using, how much money they are earning, it's not going to be a 1099. Okay, there's tax liability there, there's workers' comp liability, there's also minimum wage and overtime liability. DOL has been actively pursuing those misclassifications, and they don't plan to stop anytime soon. So they will ask, if you get audited, show me a copy of all your 1099s. And then they interview those people as well. Okay. Child labor, legal minimum age 14. There are requirements around when they can work in terms of school hour periods, having to have obviously work authorization both from parents and the state. There's a lot of requirements around that. Moral of the story is you cannot have anybody under the age of 18 in a hazardous occupation, period. Okay. You just can't. However, if you are employed by your parents, other than manufacturing, mining, or a hazardous occupation, there are some exemptions there for child labor. Okay. But general rule of thumb is 18 and under, don't you dare put them anywhere near a hazard. Okay. And then also, depending on the state, there are obviously going to be required breaks for minors. When can they work? When can they not work? Summertime has a little bit more flexibility, but during the school week, you know, they can't work before or after certain times. Okay. And there's some information that breaks that out there about child labor. So let's talk about information that FLSA wage and hour division requires you to keep. Okay, name, address, gender, date of birth, job title, when your work week begins and when your work week ends. That information should actually be in your employee handbook policy and procedure. Okay. Regular rate of pay or base salary, what the schedule is, what their hours of work are, commissions, date and payment of each covered payment. These are things that they are going to be looking at if you're audited, but also you're required underneath federal law to maintain for no less than 3 years. Okay. If we're talking about payroll information, which most of this is going to be found in payroll, right? Payroll per IRS has to be maintained for up to 10 years. Okay, so you defer to the later regulation. So here's some information on record keeping. Again, this is just wage and hours record keeping requirements. IRS has a much longer time frame. Okay, so generally 3 years for payroll, pay plans, wage rate tables, 2 years for time schedules. So where some employers get into trouble when they get audited is they're like, I don't have the schedule for Johnny from a year and a half ago. You're going to get dinged on that one because you're required underneath law to have all of the time records. Okay. And there is also some record keeping guidelines for age discrimination, which also falls underneath wage and hour division in some ways with regard to applications for employment, that sort of thing. As a reminder, you do have to keep all applications for employment received from potential candidates for at least 12 months from the date that you received them. Let's talk about some penalties for violation. So, and I'm trying to be efficient for time here, David, so I apologize. Under FLSA, they have the ability to recover unpaid wages. So when they run your 2-year look back calculation, they are going to literally employee by employee, whether they're a current employee or terminated employee, they're going to look at what the time record shows compared against the payroll record. And if overtime was not paid or incorrectly paid, they're going to run that calculation. And they're going to do that for every single person listed on the payroll record through the last 2 years. And then they're automatically going to impute liquidated damages. Okay. If you have multiple locations, please know that they will start at one location. If they find payroll errors in one location, they will open up the investigation to every single location that you own. Okay. You will have to pay the back wages and liquidated damages. Generally speaking, they will give you, they'll ask you to do it in 30 days. The most I have ever been able to negotiate was a 90-day grace period. And then you still have to send records and copies of the individual checks that you cut and the letter confirming the amount that was owed back to the employee. Okay. So what happens if you get an audit? First and foremost, do not panic on me. If you get a letter from a wage and hour investigator or one shows up at your doorstep unannounced, which can also happen, pick up the phone and you call SESCO. Seriously. Because you don't want to say or do anything that could open you up to further liability or to prohibit their investigation. They're going to come and they are going to say, I'm David McCaleb with the wage and hour investigation. You should be asking to see their badge. They have the federal badges that they flip down and show you as well, their ID. They're going to, ask to speak with so-and-so. We're going to politely defer and say, oh, so-and-so's not here today. What can I help you with? Okay. I'm here to do an audit. Great. They're going to basically, if you get the letter, they'll either hand it to you in person or they'll mail it to you. And it'll be anywhere between 10 to 14 items that you need to present to them. And they are very robust items. Okay. A name, a list, contact information for every single employee over the last 2 years. All matching time records, all payroll journals, all copies of pay plans, bonuses, commissions, all 1099s, copies of your FMLA policy and procedure. They're going to want to see your employment posters. They're going to want to see every single owner, the federal tax ID, the breakdown of senior leadership. There's a lot to pull and gather to give to them. Now, most of what Wage and Hour is doing right now is they're doing things digitally and you have to upload it into the portal, but it's not anything that you generally cannot pull all of that information in the same day. Okay. And typically they will say, oh, have this information ready. I'm going to be on site this day. We try to get a little bit of a cushion. We delay that a little bit. We ask them to reschedule. You don't want to navigate an audit by yourself. You also need to understand what their role is and what they're looking for. And whoever you are collaborating with, whether that be your employment attorney or a firm such as SESCO, we're going to be able to anticipate where we're going to run into challenges based on my review of your payroll. I'm going to say, okay, well, they're going to be looking for this. Let's get in front of it. Okay. If we need to provide them with a list of employees and help schedule their interviews, we want to do that so that we have a choice in picking who they speak with. Okay. We also need to understand that, you can't tell employees what to say. So there's a lot that goes into the investigation. There are two ways you can get one. One is complaint driven and one is random. Typically speaking, Wage and Hour does have particular industries that they focus on each year. A couple years ago, it was healthcare. More in particular, it was home healthcare. Auto service has been the last 2 years, just because of the complexity of the pay plans. So you're either going to have a complaint and they won't tell you who complained. It could be somebody that currently works there or somebody that has previously worked there. Okay. So you have that. And the whole point is you want to be agreeable. You want to be flexible. You want to be supportive and work alongside the investigator, but also make sure that we are only giving them exactly what they ask for and nothing more. Okay. So, here's some vulnerability areas that they look for. Falsification of time records, managers going in and changing time records without the employee authorizing and signing, this is my true and accurate time card. Discrimination charges, hours of work that have not been recorded or paid. All of these things can add up very quickly. Okay. So these are things that I also look for when I audit with clients. So what do? How do we make sure that hopefully we don't get an investigation? I mentioned earlier, you should be auditing every year, at least every other year. Okay. Your managers need to be trained on proper Wage and Hour pieces as well. With the Wage and Hour investigator, again, really, I strongly encourage you to partner with somebody who's an expert in Wage and Hour accounting and let them serve as your agent of record. It is a very stressful process, and it can be confusing if the language that the investigator is using because of the complexities of Wage and Hour, and they're going to start throwing out codes and field handbook operation guidelines say da 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 da. You want somebody that speaks their language, okay, and that can interpret in layman's term back to you as the employer. What does this mean? But also be able to represent the employer in an appropriate way and be able to explain to the investigator, no, in fact, this is how we've been calculating the straight time, or the retail 7I exemption is applied to this, et cetera, et cetera. There are ways to support the employer to help bring what could be $200,000 all the way down to $10,000. There are ways to get credit and pull case law and do all these things to support your case. So it's really, really important that you partner with somebody that knows what they're doing. Once wage and hour has done their calculations, we review it. We do a closing meeting. If there is a rebuttal or a response, your agent of record will do that for you. Never blindly sign what wage and hour presents to you. You always have your counsel review it. It is not uncommon for the wage and hour investigator to make a mistake. They're human, just like we are. They may have misapplied something, their numbers could have been off. That's why we always review it. And that's why we stand ready to make an argument as to why their findings may or may not be correct. Okay. So those are just some tips there. Overall, make sure you're doing a good audit. Have a timekeeping policy about clocking in and clocking out. How managers should be addressing missed punches and edits. And make sure that we're editing time records before payroll runs so that we don't have to go back and change payroll as well. Make sure everybody is on the same page about breaks, lunches, overtime, after hours work, exempt status, pay plans, all of those things. Okay. I know I threw a lot at you in a very, very short amount of time. But you know what, David, 18 minutes over isn't too bad.
No, that's fantastic. We do have a few questions, but why don't I summarize those in email and
Okay.
send them to you, and then we can get in touch with those people. I've got their names. As long as they did register under a pseudonym, we've got them.
There you go.
But thank you so much, and again, thank you everyone who attended. If you are if you're a client, then you have complimentary access, basic access to SESCO, to a SESCO counselor. So reach out to your sales exec. They can tell you how to do that. For those of you that I've been commenting on here, we will get back in touch with you. And if I've told you that we will, we'll make sure your sales exec gets a hold of you directly. But thank you. Thank you, Jamie. Thank you, everybody who attended and for your interest. And I will send out here in a bit, probably this afternoon, the recording along with the presentation, and we'll go from there. Thank you so much.
Sounds good. Thanks, everybody. Take care.